On January 24th, 2025, Sam Tunick steps off a plane in Atlanta after a vacation in the Dominican Republic. He was whale watching. It was a normal trip. 3 hours before he landed, unbeknownst to him, federal agents were already circulating an email with his name, his photo, and a note that he's under investigation for suspected terrorism activities. The reason? His alleged connection to the movement against Cop City. What happened next turned a privacy feature on his phone into a federal felony, and the government is now trying to call the whole thing a routine search. So we're going to take a look at what happened. We're going to take a look at the docket. We're going to take a look at all of it. So here we go. Let's talk about the airport search. So Sam gets pulled into secondary inspection at Hartsfield-Jackson Airport in Atlanta. Present are both Customs and Border Protection's Tactical Terrorism Response Team and an FBI Joint Terrorism Task Force officer. And so Sam Tunick is already on a terrorism watch list because of the Cop City stuff. So he's taken into a room, there's a camera, there's a microphone, he's at a table with multiple agents, and they start asking him about child sexual abuse material. We're going to say see Sam for the rest of the video. His lawyers say that that was just a pretext. It's a fishing expedition into his political associations. He asked for a lawyer 4 times. They tell him no every single time. They never read him his rights. They tell him they don't need a warrant because he hasn't officially been let into the country yet. And then they demand he unlocks his phone. After some back and forth, he eventually gives them a passcode. When one of the officers enters the passcode, though, the screen goes blank, flashes a few times, the phone restarts, and lo and behold, the phone is wiped. The phone was running Graphene operating system. It was a Google Pixel phone, and that open source system has a Duress pin. It's a second code that factory resets the device if you enter it. Agent sees the white phone anyway, and they tell him he's free to go. So they have the device, but they say he's free to go. And again, this was all back in January of 2025. 11 months later, they indict him under a rarely used statute, 18 U.S.C. section 2232A, which deals with destroying property to stop the government from seizing it. In other words, they're saying that the wipe itself, prompted by that passcode that Tunick provided, is itself the crime. Tunick pleaded not guilty, and we're going to look at that docket towards the end of this video. But when this came across my radar and I started looking at it, security people who seem to watch this type of area of the law, say they haven't really seen a U.S. case like this before, charging someone for using what we're going to call a duress password. And so I was intrigued, and as I kept reading, I learned about what happened at a hearing on July 20th that just took place, where a Justice Department attorney and Customs and Border Protection officer Larry Finley, he gets on the stand, he's testifying, and he says that this was all a routine search. Just looking for anything prohibited. It was routine. But how? And that's the type of moment when I read something like that, that's the hook, line, and sinker, where now I feel invested in a case and I want to see how this plays out. That how is huge. How do they have an email out 3 hours before this plane lands stating that, look, we're interested in investigating Sam Tunick because of whatever ties, Cop City protests, this environmental movement, and they have him on this terrorist watch list for political activity, but it's a routine, it's just routine. Like, this could happen to anybody, there's no targeting. It's just odd that the testimony that it's routine doesn't compute with the other context. If you have FBI and CBP there, and if the line of questioning focuses on CSAM, even though the defense says there was zero indication of that, there was no basis for it, in other words, then how are they treating this like a routine stop while also at the same time telling this U.S. citizen he had no right to a lawyer? And that's where I think we get this muddying of lines where, hey, is this something that CBP, Customs and Border Protection, have these expansive powers to be able to do this type of thing? Or are we in FBI territory? Is this something that was happening at the behest of the Federal Bureau of Investigation? And where do those rights sit? This right to a lawyer, the failure to read somebody their rights. And so this characterization, according to the officer's testimony, that this was routine, I think is problematic. My opinion, it seems like they were targeting Tunick, but now that routine language is how they're going to try to keep this massive power of the border search exception. Because if it was just a normal border stop, they get more leeway. But if it's a pre-planned domestic investigation that happened to take place at the airport, then the Fourth Amendment starts looking like it's a lot more relevant. And so I think there's this tension sitting right at the center of this case that, very interesting. I think it's very interesting. Anyway, so because of this hearing, I believe that's why a couple of outlets were starting to cover this case. We're going to link those in the description. Check those out. They lay out the basic facts and context. This appears to be the first time the government has tried to criminalize a duress pin. And otherwise, major coverage has been pretty quiet so far, although a lot of discussion erupted about this case on X over the weekend. So if you want to look for the primary reporting, start with those articles. And then from there, let's get into the actual court file. Let's go to the docket. So this is United States v. Tunick. This is in the Northern District of Georgia, and it's available on Court Listener, so that a quick link in the description to that as well. The indictment came down on November 13th of 2025. Just one count. He gets arraigned December 3rd, he pleads not guilty, and he gets a $10K bond. On March 17th, which is going to be the primary focus of the rest of this video, his federal public defenders file a motion to suppress. They're asking the court to throw out the statements and anything that came from the phone, with three main arguments. First, that he was in custodial interrogation. There was no Miranda, he asked for a lawyer repeatedly, and he was ignored. Fifth and Sixth Amendment problems. Next, they argue that everything that flowed from those statements, including the fact that the phone was wiped, so the words, the statement, giving that pin, would be fruit of the poisonous tree. And then they also argue that the search itself violates the Fourth Amendment, with the argument being that the border exception doesn't stretch this far when the stop is a pretextual fishing expedition into domestic political activity. And then on July 20th, there is an evidentiary hearing in front of Magistrate Judge Christopher Bly. 3 CBP officers testify. The government puts the pre-arrival email into evidence. The judge leaves the hearing open so they can finish one more witness's testimony later. And then we get a briefing schedule. So the defense has to file their post-hearing opening brief by September 18th. The government has until October 9th to respond. And then the defense gets their reply to that. Their deadline is October 23rd. So that's a ways away. But after that, the court will decide whether this evidence stays in or it gets thrown out as fruit of the poisonous tree. So later this fall, let's tune in. Let's pay attention to where this moves. We'll also look at those briefs. I'm very interested in this argument. And if the motion were to win, I mean, the government's case is in serious trouble. If it loses, then we're looking at a precedent that says that using a privacy feature under these conditions can be a federal crime. And I'm thinking about the recent SCOTUS decision in Chattree v. United States, which dealt with geofencing, but there was a lot of discussion around smartphones are something that we have in our pocket, have on our person, day to day. Is it, if we're going through an airport, is our smartphone, should we look at that the same way as we might look at if I'm carrying a suitcase or a briefcase with a bunch of documents in it and it's locked and I unlock that would it be the same as me ripping up those papers or chewing it and swallowing it so you can't read it versus giving you something that wipes the phone? And frankly, I think it's a case that goes way beyond any connection to Cop City, whether you're following that or not. There's been some interesting legal back and forth with that case if you dive back through the statewide history, and then recently there was a federal indictment that came down. And so ultimately, this isn't just about this one guy or one guy's phone, in my opinion. I think there's a great deal of nuances. We're dealing with smartphones that carry a tremendous amount of information, and they're almost like an extra appendage most people walk around with. Privacy software. What does this mean for privacy software? Is there an inference that something nefarious is going on if you have these types of softwares or applications? I watch a lot of court cases, and a few different cases, there's been these questions with a tone that implies something nefarious is going on when someone's asked, and were you using the app Signal? So what does this case mean for those types of software and applications, whatever have you? And what does it mean if somebody's technically pulled aside in a border area, at an airport, but the pretext is a domestic investigation? What does it mean if you're denying them a lawyer at that stage? Is it a gray area? Do we need to have more clarity there? What's the difference between routine? What's the criteria for whatever stated reason actually just being a pretext? And ultimately, is such a search lawful or not? So let's do our docket dive on U.S. v. Samuel Tunick. So first up, we have the criminal indictment. This was filed under seal, and then it was unsealed. This was dated November 13th, 2025, and it says, the grand jury charges that, on or about January 24th, 2025, in the Northern District of Georgia, the defendant, Samuel Tunick, before and during the search for and seizure of property by Customs and Border Patrol Tactical Terrorism Response Team Supervisory Officer LC, they're using initials, a person authorized to make such search and seizure, did knowingly destroy, damage, waste, dispose of, and otherwise take any action to delete the digital contents of a Google Pixel cellular phone for the purpose of preventing and impairing the government's lawful authority to take said property into its custody and control in violation of Title 18, Untied States Code. We have a typo here. Section 2232A. Signed, we got the true bill here returned. And here we have Theodore S. Hertzberg and Matthew S. Carrico. He got Rico in his name. Here for the United States. So there we go. That is the indictment. And on March 17th, we have the motion to suppress. So we're going to read that in full. And again, that was the subject, that and the motions to modify conditions of release, which was granted, were the subject of this recent hearing that happened about a week ago. So here we go. We got the motion to suppress evidence and statements. The defendant, Samuel Tunick, through undersigned counsel, moves this court to suppress statements and evidence obtained in violation of Mr. Tunick's constitutional rights. First, Mr. Tunick's statements should be suppressed because they were obtained in violation of the Fifth and Sixth Amendments. Mr. Tunick provided officers with the password to his phone and e-reader during a custodial interrogation. So they're framing this as they're saying it's custodial, during which Mr. Tunick was not provided with Miranda warnings and repeatedly invoked his right to an attorney and requested an end to his questioning. For the government to use any statement attributed to Mr. Tunick, it must first prove that his statements were made voluntarily and not in violation of his Fifth and Sixth Amendment rights. And they cite here Jackson v. Deno, Miranda v. Arizona, and Escobedo v. Illinois. Second, because the officers violated Mr. Tunick's constitutional rights during their interrogation of him, evidence obtained from Mr. Tunick's phone, or lack thereof, they're pointing out you don't really know what was in there. Evidence obtained from Mr. Tunick's phone, or lack thereof, should be suppressed as fruits of unlawfully obtained evidence. And is this United States v. Chantasuhat? I don't know how to say that, sorry. And then Wongsun v. United States. Third, any evidence obtained from Mr. Tunick should be suppressed as a product of an unreasonable, warrantless search and seizure that violated the Fourth Amendment, citing there Riley v. California and United States v. Agbakan. Though the officer's detention, interrogation, and search of Mr. Tunick and his property occurred at Hartsfield-Jackson Atlanta International Airport, officers were not permitted to disregard all constitutional protections afforded to Mr. Tunick simply because he was at the border. Here's the background. The one-count indictment alleges that Mr. Tunick destroyed the digital contents of his cellular phone to prevent an officer of the Customs and Border Patrol Tactical Terrorism Response Team, CBP-TTRT, from searching and seizing the contents of his phone. So footnote here says Title 18 U.S.C. 2232A prohibits one from knowingly destroying, damaging, wasting, disposing of, or transferring property for the purpose of preventing or impairing the government's lawful authority to take such property into its custody or control by a person authorized to make such search or seizure. So let's see where you think they're going to go with their argument, since they're specifying this in a footnote. They say on January 24th, 2025, FBI Atlanta Joint Terrorism Task Force Officer Burnham and FBI Special Agent Andrea Coble coordinated with CBP to question and search U.S. citizen Samuel Tunick as he was returning to the United States from the Dominican Republic. The government was investigating Mr. Tunick because of his association with an environmental movement known as Defend the Atlanta Forest, which opposed the destruction of the South River Forest for the construction of an 85-acre, $115 million police training facility known as the Atlanta Public Safety Training Center, which colloquially has been called Cop City. While the government depicts the Defend Atlanta Forest movement as an anti-government, anti-authority, violent extremist group, it has not put forth evidence that Mr. Tunick was involved in criminal activity in connection with the Defend the Atlanta Forest movement. When Mr. Tunick arrived at the airport on January 24th, CBP placed him in secondary inspection. CBP's Tactical Terrorism Response Team proceeded to question Mr. Tunick, searched Mr. Tunick's body and all his belongings, and insisted that he provide the passcode for his phone. Despite Mr. Tunick's request to speak with his lawyer and not engage in further questioning, the officers insisted that they could question Mr. Tunick and search his phone to determine whether he had child porn. Evidently, this was a pretext for a fishing expedition into Mr. Tunick's connections with the Defend the Atlanta Forest movement. The two CBP officers conducting the initial interrogation of Mr. Tunick never read him his Miranda rights, and further, Mr. Tunick stated early in the interview that he did not want to continue speaking without a lawyer. Yet the officers repeatedly ignored Mr. Tunick's request to speak with his lawyer, continued to question him, and declared, "Because you're refusing to talk, which is your right, we have the authority to go through your phone to see what we're looking for." After the officers requested Mr. Tunick's cell phone password a second time, Mr. Tunick asked again why he was not allowed to call his lawyer, and the officers responded, "When it comes to immigration and customs, right, it's a whole different ballgame, and we have search authority, we don't need a warrant." The CBP officers explained that Mr. Tunick would have to give the officers access to his phone, whether it was done with his cooperation or not, and eventually, Mr. Tunick provided a password to his cell phone and e-reader. According to the government, when the CBP officers entered the password on his cell phone, The screen went blank, flashed several times, and the phone appeared to restart. Can you imagine sitting in that room and watching their face as this happens? And, realizing, processing, well, that's weird. That's usually not what happens when I try to unlock a phone. Oh. After they attempted to search Mr. Tunick's phone and inspected every item in his bag, a third officer entered the room to conduct a pat-down of Mr. Tunick. Mr. Tunick responded that he did not consent to the search of his body, but recognizing that he had no choice in the matter, the officers escorted him to another room for the search. The officer's search of Mr. Tunick was not recorded, but when Mr. Tunick returned, the camera captured him putting back on his sweatshirt. Finally, an agent from the Department of Homeland Security, or DHS, along with 3 additional agents, arrived to conduct another interview of Mr. Tunick. Mr. Tunick declined to be interviewed and pointed to his attorney's card already placed on the table. The agent explained that he was seizing Mr. Tunick's electronic devices, and they would be returned to Mr. Tunick after 30 days. Notably, the DHS agent explained that Mr. Tunick was not under arrest, but once these gentlemen are done with you, pursuant to your entry into the country, you're free to leave. The DHS agent stated this after the CBP officers had pressured Mr. Tunick to provide his cell phone password, and more importantly, the DHS agent said Mr. Tunick was free to leave only after these gentlemen, the other agents in the room, were done with Mr. Tunick. In other words, Mr. Tunick was not free to leave at any time. Next up, we have officers violated the 5th and 6th Amendment by interrogating Mr. Tunick without administering Miranda warnings and disregarding Mr. Tunick's request to speak with his attorney. To protect the 5th Amendment right against self-incrimination, Miranda requires all individuals who are in police custody to be informed prior to interrogation of their right to remain silent and to have an attorney present during questioning. It's Miranda v. Arizona. An interrogation is custodial when, under the totality of the circumstances, a reasonable man in the defendant's position would feel the restraint on his freedom of movement to the extent that he would not feel free to leave. With respect to interrogations at the border, the 11th Circuit has stated that questioning at the border must rise to a distinctly accusatory level before a reasonable person would feel restraints on their ability to leave. That's from United States v. Moya. The government has the power to police national borders, and as such, the 5th Amendment guarantee against self-incrimination is not violated by routine questioning. Routine of those seeking entry into the United States. That's from United States v. Luke, from the 11th Circuit. While an interrogation at the border might begin as non-custodial in nature, when officers start accusing a defendant of criminal activity, a reasonable person could feel a degree of restraint comparable to arrest. At that point, the interview can become custodial in nature, and the officers are required to administer Miranda warnings. United States v. U.S.C. from the 11th Circuit. In U.S.C., the 11th Circuit reasoned that defendant Padilla's initial interrogation at the border was not custodial in nature. He was not handcuffed, not physically held or moved, nor was he told that he was not free to leave. Nothing indicated that Padilla asked to leave or see a lawyer before the agent's accusation that Padilla was linked to terrorist activities. However, once the agent accused Padilla of terrorist activities, the interrogation became custodial, and it is evident by Padilla's reaction to the agent's accusation. He stood up and announced that the interview was over. Here, the CBP officers introduced themselves to Mr. Tunick and explained that they were looking for people who were pedophiles. The officers never read Mr. Tunick his Miranda rights. The officers justified their questioning and demands to search Mr. Tunick's phone by stating that they had to confirm whether he possessed child porn. The officers never provided any details as to why they purportedly suspected Mr. Tunick was harboring such contraband. Then we have this testimony, right? Foresight, we get this July 20th hearing and this testimony where it was a routine search. Now, I don't believe I know of anybody who's been through a routine search at an airport where they're taken aside for a secondary inspection and one of the officers or a group of officers goes, oh, we just need to make sure we don't have any CSAM on your phone or in your suitcase or whatever. Just routine. The government's reports do not indicate any suspicion whatsoever, that's italicized, that Mr. Tunick was in possession of child porn, but rather that their purpose in detaining Mr. Tunick and seizing his belongings was to investigate his ties with the Defend the Atlanta Forest movement. And I think this just goes to cops can lie. Although the officers' accusations that he possessed child porn were pretextual, the officers were nevertheless accusing him of criminal activity. So there you go. The lie is still accusing him of criminal activity. These accusations, combined with the fact that the officers continued to steamroll Mr. Tunick's request to end questioning and speak with a lawyer, illustrate how a reasonable person in Mr. Tunick's position would not feel free to leave. Weigh in. What do you think? Would you feel free to leave? Mr. Tunick was not free to leave because he was being subjected to custodial interrogation, requiring officers to inform him of his Miranda rights. The 11th Circuit has held that an individual's act of decrypting and producing a hard drive's contents is sufficiently testimonial to trigger Fifth Amendment protection. So this is, let's see, from 2012, In re Grand Jury Subpoena Ducis Tecum. Similarly, requiring Mr. Tunick to provide a passcode for the officers to search through his phone is sufficiently testimonial to trigger Fifth Amendment protection. However, Mr. Tunick was never informed of his Miranda rights. Further, because Mr. Tunick's repeated requests to speak with a lawyer were denied while he was under custodial interrogation, his Sixth Amendment rights were violated. As such, Mr. Tunick's statement should be suppressed as involuntarily made and in violation of the Fifth and Sixth Amendments. Next up, the evidence obtained from Mr. Tunick's cell phone should be suppressed as fruit of his unlawful interrogation. Officers violated Mr. Tunick's constitutional rights in their interrogation of him, and in turn, evidence obtained from Mr. Tunick's phone, or lack thereof, should be suppressed as fruits of his unlawful interrogation. The fruit of the poisonous tree doctrine, which requires suppression of evidence derived from other unlawfully obtained evidence, can apply beyond the Fourth Amendment context. For example, evidence derived from an involuntary statement should be excluded from trial as fruit from the poisonous tree. And that's from United States v. Law. In United States v. Patain, the Supreme Court denied suppression of the non-testimonial fruits of a statement obtained in violation of Miranda. Yet Patain is distinguishable from Mr. Tunick's case. First, the fruit of Mr. Tunick's un-Mirandized statement, the alleged wiping or encryption of the contents of his phone by providing agents with a specific password, is testimonial in nature. Second, unlike in Patain, where the defendant interrupted the detective while he was administering his Miranda rights, and the defendant never invoked his rights to an attorney, the CBP officers never attempted to advise Mr. Tunick of his Miranda rights and ignored his request to speak with his attorney. And they're citing here United States v. Owens from the Northern District of Florida from 2009, determining that Patain was never controlling because the officers never attempted to advise the defendant of his Miranda rights prior to interrogation. Third, the officer's search and seizure of Mr. Tunick's phone is significantly more intrusive than the seizure of defendant Patain's firearm. Yeah, I mean, that's distinguishable, wouldn't you say? See Riley v. California, 2014. Unlike the search of a bag or physical items, a cell phone can reveal the sum of an individual's private life. And again, I think that's a sentiment that SCOTUS just kind of took a look at a little bit, an initial gander, a light gander at in Chattree. Patain is factually an opposite of Mr. Tunick's case, and therefore his phone and its contents, or more accurately, his alleged wiping of the contents of the phone by providing a specific password to the officers, should be suppressed as the fruit of Mr. Tunick's unlawful interrogation. Right? And it might seem like over-precise, but being over-precise here, being precise, not over-precise, but being precise here is important, because if it was just somebody taking their own device and doing something, then you can't argue that that's a testimonial statement. But because there's more nuance than that here, there's more context, this is really an exchange of a back and forth. Tunick eventually gives a PIN. That PIN is entered by one of the officers on the device. The device restarts and it's wiped. All right, but that entails a statement being given. And that statement, having a statement at all, is critical to being able to argue that something would be testimonial or not. Next up, we have the evidence obtained from Mr. Tunick's cell phone should be suppressed as the product of an unreasonable search and seizure under the Fourth Amendment. So the Supreme Court has expressed that the primary justification for warrantless searches at the border is to prevent contraband from entering the country. Maybe that's the basis behind the pretext. So they cite here Montoya de Hernandez and Carroll v. United States. Nonetheless, the 11th Circuit has held that a forensic search of electronic devices at the border is constitutional despite the lack of a warrant, probable cause, or individualized suspicion. That's United States v. Toussaint. Generally, the 11th Circuit applies a two-step analysis, right? Okay, so it can be permitted, but generally you got to do this two-step analysis to evaluate the legality of a border search. That's from United States v. Polito. The first step focuses on whether there was statutory authority to conduct the search, and the second step asks whether the search was reasonable under the Fourth Amendment. As the level of the search's intrusiveness increases, the amount of suspicion needed to justify the search should increase. However, the 11th Circuit's decision in Doucette contravenes the primary principle behind warrantless border searches. The notion that suspicionless searches of phones at the border are permissible to prevent contraband from entering the country is unwarranted. Unlike physical contraband such as drugs, digital contraband can exist in multiple locations and formats and is easily transported across borders via the internet. In the case of Mr. Tunick, where the accusation is that he destroyed the digital contents of his phone, where was the threat of contraband entering the country? There wasn't one. Rather, in Mr. Tunick's case, law enforcement coordinated and planned his detention before he arrived at the airport. The purpose of his detention at the airport was to investigate domestic crimes connected with opposition to the Atlanta Public Safety Training Center's construction in the South River Forest. Mr. Tunick has not been charged with committing a crime in connection with the Defend the Atlanta Forest movement, but law enforcement seemingly took advantage of the relaxed constitutional protections at the border to try to dig up evidence against Mr. Tunick and possibly others connected to the movement. While the 11th Circuit's decision in Doucette suggests that it's permissible for law enforcement to circumvent a person's constitutional rights by investigating domestic crime through warrantless searches and seizure at the border, other circuits disagree. The 4th Circuit has held that warrantless searches of digital devices at the border may not be justified to search for evidence of a crime, even if there is probable cause that the defendant committed the criminal offenses in the country. Indeed, the 11th Circuit's decision in Doucette is inconsistent with other circuits' decisions on warrantless border searches. And here they reference a First Circuit case holding that a non-routine search must be supported by reasonable suspicion that the search will uncover contraband or evidence of a crime. Also, United States v. Kulsitz from the 4th Circuit, stating that borderless warrant searches are not permissible for purposes of general crime investigation. United States v. Kano from the 9th Circuit, holding that articulable suspicion is required for an intrusive forensic search of a digital device and that a border search is not a vehicle for criminal law enforcement. In conclusion, Mr. Tunick respectfully requests that the court issue an order suppressing all constitutionally obtained statements and evidence, 2, grant the defendant a suppression hearing, 3, allow additional briefing on this issue if there is an evidentiary hearing or additional evidence on this matter, and 4, grant such other relief as may be just under the circumstances of this case. So this was the 17th day of March 2026, Melissa McGreen from the Federal Defender Program. So there we go. There is the motion to dismiss. And then we've got the scheduling order. So we're going to get those briefs towards the fall, and that we're caught up on the docket there. We are caught up on the docket there. Weigh in on what you thought about the arguments within that motion. So there we go. That's our docket dive on U.S.V. Samuel Tunick. But other than that, all of the documents are in the description. The next few months as they approach with these different briefings, I think that'll tell us a lot more context. And that's where we are right now. Let me know what you're thinking about this. Let me know if what angles come to mind, any cases that you're thinking of. Where do you think the line in the sand should be drawn? And hit that like button on the way out. Hope you like this video. See you guys soon.